Section 3. Trademark Registration Proceedings. As we explained in the previous session, it is different from the US, where you may establish a legal right for the use of a mark by means of use in commerce. You have to have your mark registered in China in order to establish exclusive rights to use a mark for your business. A mark must be registered through the National Trademark Registration System in China with the Trademark Office of National IP Administration of China. The Trademark Office has been operating a database, a website allowing anyone to do trademark search, registration, and protection online. So this is the website maintained and operated by the Trademark Office of China. It is a centralized platform available to anyone, the trademark owner and trademark agents and foreign trademark applicants. You can register your trademark abroad at any time, or on the other way, you can have your trademark registered in China and then have it registered in other countries, or you can also have your trademark registered in another country and then come to China looking for a Chinese registration. But you have to keep in mind that you usually have 6 months from the date on which you applied for protection in the first country to claim the rights of priority for trademark protection in other countries. We will be back to this topic in the following slides. In other words, if you registered within the 6 months period and your registration is successful, it will be regarded as having taken effect from the date on which you filed for protection in the first country. To register our mark in another country, in other countries, there are three main ways to do it. Number one, the national route. You may apply to the trademark office of each country one by one, in which you are seeking protection by filing the corresponding application in the required language and paying the required fees. For instance, you apply for registration in China with the trademark office of China, and then you move on to the Japanese trademark office, and then to the US trademark office, and then European trademark office. So you can go up to the trademark office of each country, visiting them one by one. But given the limits of time, you have to have someone or some professionals to help you to formulate the registration documents and strategies, because you have to have your application documents translated into the language required by the corresponding trademark office. Alternatively, you may also have your mark registered through the regional route if it's available. For instance, if you want to protect your trademark in countries where are members of a regional trademark system, you may apply for registration with effect in the territories of all member countries by filing an application at the relevant regional office. For example, the European Union Intellectual Property Office, EU IPO, and with the African Regional Intellectual Property Organization, ARI IPO. The international route, that is so-called the merit system. If your home country is part of the merit system and you have a national or regional registration or application for a trademark, you may be able to use the merit system to register that same trademark in any of more than 90 members of the merit system. But keep this in mind that this is not international trademark system. This is very different as from the community registration collaborations in your European Union, for instance, with the EU IPO where you have your trademark registered with the EU IPO, your trademark is considered as a community mark, and you can get your mark acknowledged and protected in any member countries in European Union. Whereas the so-called merit system is merely an international collaboration system to facilitate the registration process of a trademark in more than one countries. Basically, it means you first need to register your mark or apply for registration in the office of the country with which you have the connection. This office is referred to as the Office of Origin. Then you can ask your Office of Origin to send your application for international trademark registration to WIPO for formality checks, and then the international application must designate the countries in which the mark is to be protected. For instance, if you are a Chinese applying for registration in China and submitting your trademark registration request to the Trademark Office of China, and then you may ask the Trademark Office of China to forward your application to WIPO under the merit system and looking for registration in other countries. And those countries, of course, should be nominated by you. You say, I also want to have my mark registered in Japan, the US, Africa, and countries, and other European countries. Let's say 10 foreign countries. You have all those countries selected, and then the Beijing or the Trademark Office of China in Beijing will forward your documents to WIPO, and then WIPO will distribute your documents to the trademark offices of those countries selected by you. And each trademark office would do examination under their national law. If successfully registered in Japan, in the US, that restriction would be regarded as a US trademark or Japanese trademark. So separate 10 trademarks. That's why we say the merit system is not an international trademark system. It's not an international trademark registered through that system. It's merely a mechanism of international collaboration mechanism for registration for applying for registration of a trademark in more than one countries. But in the United States, as we explained earlier, legal rights to a mark can be established through continuous use in commerce. But federal registration of trademark is also highly recommended because with federal registration, you would obtain significant advantages. Let's say, what is a trademark registration in the United States? This video gives you a very brief introduction to the key issues of federal registration in the US.
So what is federal registration of a trademark? Well, pursuant to the Lanham Act, a federal statute allows individuals to protect their mark nationally throughout the United States borders by filing federally pursuant to the statute. Now, you still have the application goes to the U.S. Patent and Trademark Office and will be reviewed by a trademark examiner and has to meet all of the elements required for filing a trademark. But if accepted, this registration gives tons of benefits above those of state court registration. It allows the holder of the trademark rights to enforce their trademark rights against infringers or others throughout the entire border of the United States. But above that, it allows a few other advantages. First, the individual enforcing their trademark rights can bring federal action rather than just a state court action against the individual. There is a presumption that must be overcome by the defendant that the trademark rights being enforced are valid. Okay. It also it puts others on notice of the mark. So the mark will be recorded in a trademark database or system, so individuals searching it will be able to identify it and know that there is trademark protection throughout the United States. And again, these things taken together, the jurisdictional aspects of it, of being able to enforce your rights anywhere, are potentially the biggest benefit associated with national filing.
Well, the national registration system in China is it's not compulsory, right? You can, of course, use your mark without registration, but that will be very risky for your business, and because the exclusive rights in the use of the mark cannot be established through a continuous use, as what they been doing in the US, as you already see. And so here in China, you have to do a national registration, and the Chinese trademark law follows so-called the force to fire principle. It means the first applicants to file an application for registration of a mark will preempt all other later applications for the same mark in the same class. If two or more applications are filed for the same trademark in the same class on the same day, the trademark used first shall be accepted. It also emphasizes that any registration must be based on good faith. So bad faith registration could be cancelled, and because this is a compulsory statutory requirement for trademark registration. It means if you don't have any intent to use a mark, could be a very famous mark in other countries, and then you have all those foreign marks registered in China, and looking for opportunities to sell those marks to foreign trademark owners in the future at a very high price. It could be considered as a bad faith registration. As the trademark system adopts so-called falsifier system, so the date of filing will be critical to decide who is the one applied the trademark first. As we explained earlier, if you ever applied a trademark registration in a foreign country and then came to China applying for registration with the Chinese Trademark Office, within 6 months of the date on which an applicant for the trademark registration first applied for the registration of its trademark in a foreign country, and the applicants apply for registration of the same trademark for the same goods in China, it should be entitled to have the rights of priority pursuant to the international agreements signed between China and those countries. And you may also claim rights of priority if you displayed your trademark for the first time, use it in an international exhibition. Classification of goods and services, as we explained in the previous session. China used the international classification of goods and services under the NITS agreement. Products and services are classified into 45 products and services classes. But China is unique in further dividing those classes into subclasses. Products in the same subclasses are often treated as identical or similar. The proceedings to obtain a trademark registration is quite similar from country to country. Basically, step one, you have to select a mark, right? And conduct a search for priority rights and then you decide to register a word or figure. Then select the categories of all the classes of goods or services for which your marks to be useful. Step 3, prepare and submit application documents and pay fees. Step 4, the trademark office will do examination. Step 5, the trademark office will publish your application and make it available to the public for opposition. Step 6, registration. If no one raise any opposition and all the opposition is denied by the trademark office, after registration, you have to maintain your registration. It must be used. It cannot be abandoned. You have to renew it every 10 years. So it means that even you've already registered successfully a mark, but on the Chinese law, for instance, without using it for 3 years, your mark could be cancelled. So that is the process quite similar from country to country, right? And there's a detailed flowchart of trademark registration proceedings in China. You submit the application, and then the trademark office will do preliminary examination. And if it's okay, the trademark office will publish your application for opposition within 3 months. This period is called the opposition period. Anyone or any others who might be affected, whose rights might be affected by your registration, would have the right to raise opposition. And the decision delivered by trademark office can be appealed to the TRAB, Trademark Adjudication and Review Board, and the decision of TRAB could be sued in the court. Okay, let's take a very quick overview of the steps for acquiring trademark registration in China. The trademark office shall complete the preliminary examination within 9 months after filing and publish it, and then publish it in the Gazette, its official magazine or publication. And nowadays, the trademark office could also publish it on the website, the centralized database, as we explained earlier, which is maintained and operated by the Trademark Office of China. Next step, the preliminary approval should be published in the Gazette for a period of 3 months. This is called the opposition period. And if no one says no, the application for registration should be granted, and then the result should be published in the Gazette. In the case of appeal against the decision of disapproval, deny, Trademark Review and Adjudication Board (TRAB) shall make its decision within 9 months after the receiver of appealing. So this is basically the timeline of preliminary examination, opposition, and review of a trademark registration in China. The next key issue we shall pay attention is the so-called opposition. This is very critical legal arrangements trying to strike the balance between the applicants of our trademark registration and the public, and also any other members or persons whose rights might be affected by this registration. So during the opposition period, opposition can be raised by anyone on some grounds or by those whose rights might be affected by this registration. Um, so the different categories of grounds for opposition. Within 12 months counting from the date when the opposition period expired, a decision shall be made by the Trademark Office. If the opposition rejected, the registration application will be granted. If the opposition accepted, of course, the registration application will be denied, and applicants may appeal to TRAB. In the case of appeal against the disapproval decision mentioned above, the TRAB shall have give a final decision within 12 months after its receival of the appeal. So the most important issues you have to understand is the grounds for opposition, because this is the most important principles or rules under trademark law to determine whether a mark could be registered, and it's also about the reasons to deny trademark registration, and also the grounds, quite consistent to the grounds on which a registered mark can be cancelled or revoked. On the grounds specified in Article 10, 11, and 12, anyone may raise opposition. This ground basically being explained in previous sessions and previous slides, which are about basically the distinctiveness requirements, the formality requirements, and the requirements for accepted forms of marks and signs registerable under Chinese trademark law, as we explained earlier. And there are some signs just simply forbidden from being used as a trademark or being registered as a trademark. So under these grounds, anyone may stand up and say, no, trademark office, you shall not grant the registration to this mark. Group 2, on the grounds specified in, for example, Article 13 2, Article 13, Clause 2, Clause 3, Article 15, Article 16, 30, 31, 32. These articles are basically protecting, basically set for the protection of prior rights. So any prior rights holder or any interested party may raise opposition against a registration application here. So not anyone can raise opposition under these grounds. Only those whose rights being affected by this registration could stand up, hands up, and say, please reconsider this application, because if this restriction to be granted, my rights would be jeopardized. For instance, this guy trying to register my name, my family name, for instance, and everyone know my name, Michael Jordan, for instance, and if this restriction is granted, that will be detrimental to my rights, say in my name or even in my personality. If no opposition arising from the application, or if the opposition is rejected by the trademark office, then the Trademark Office will grant trademark registration. For a trademark application, which is eventually granted, even in the case of opposition and re-examination, the registration is considered effective upon the date when the 3 months opposition period expired. So a trademark registration take effectiveness on the date when the 3 months opposition period expired, not on the date of granting, not on the date of filing. So that's a very critical date for you to keep in mind. Post-granting proceedings, which includes the cancellation and invalidation under Chinese trademark law, which is quite different from those in other countries. Because in Europe, for instance, there's only one post-granting proceeding that's called cancellation of trademark, registered, based on absolute or relative grounds. Whereas in China, we have separate lines to invalidate the registration. Not there are slight differences or tiny differences between the two proceedings, cancellation and invalidation, just different grounds, different course of action. Cancellation because of the trademark owner's situation be changed. For instance, the trademark owner may apply for canceling the trademark registration of the trademark owner fails to renew the registration, or the trademark owner is dead. Cancellation initiated by Trademark Office. Number 1, 3 years of non-use. It means even a trademark is successfully registered with the Trademark Office, in 3 continuous years, the mark has not been used at all. Then this registration could be cancelled by the Trademark Office. So it's just pointless if you don't have any plan to use a mark and you register hundreds of trademark. Basically, it's useless and meaningless. It's just a waste of time and energy and resources. But sometimes it could be useful for you to defend a registered trademark by having the mark registered much more extensively to cover more classes of goods than that's necessary. But it's quite risky. Number 2, the registered trademark has become a generic term. For instance, cell phone was a trademark, right? Jeep car was a trademark, aspirin was a trademark, but now they all became a generic term referring to that species of things or goods or the name of products. Number 3, non-compliance use. The trademark registered must be used following the instruction on the trademark law. For instance, you cannot have your logo modified in a significant way, which looks basically another trademark, and then you claim it's a registered trademark. Invalidation. Apart from the cancellation proceedings and those reasons for cancellation, another separate line of grounds on which a mark can be invalidated are absolute grounds, and a trademark registration can be invalidated on the Trademark Office's own initiative or upon the request of anybody. if the registration is successful, but this registration is in violation of Article 10, 11, 12, or by means of deceptive or other improper means. So basically, the registration was a mistake, was an error by the Trademark Office, and anyone and or the Trademark Office itself may cancel, invalidate this registration. So these are absolute grounds for registration. This means anyone may apply for cancellation or invalidation. Number two, relative grounds. Relative grounds for invalidation means those grounds can only be the grounds for invalidation initiated um, by the parties or the individuals or companies whose rights being affected by the registration. For instance, the registration is obtained by in violation of Article 13, 15, 16, 30, 31, 32. This, as we explained earlier, which is quite consistent with the grounds of opposition, right? Remember? So this includes all relative grounds and to protect the rights of private rights owners. For instance, your rights in your name, in your image, or in your reputation, whatever. Number two, the owner of a prior rights or other interested party may request to invalidate the above mentioned bad faith registration within 5 years, counting from the date when the registration is or was granted. It means, for instance, Michael Jordan, right, tried to oppose a successful registration of the Jordan mark in China to be used for shoes, sport shoes, or clothes. But when Michael Jordan was realized that his rights could be infringed, his rights in his name could be infringed by this registration is being more than 5 years, counting from the date of that Jordan mark being registered successfully in China. Um, or if someone registered a mark which bears a copyright work created by you, you would have the rights to invalidate this registration within 5 years. So 5 or 6 years later, you cannot say, okay, I want to invalidate this mark because that's infringing my copyrights. And that image, that logo was my design. No, you have to do this within 5 years. But there's one exception. But the 5 year limit is not applicable to bad faith registration of well-known marks. For instance, well, just for unknown reasons, you successfully registered Chanel uh, as a trademark for in a specific class. For instance, for products such as toilet products, Chanel, a brand for toilet products, and that of course that was a mistake. The trademark office should not grant that registration, but um, it is a trademark. It is a mistake or error made by the trademark office. That error, of course, is possible and to some extent allowable under trademark law. Allowable means given the limits of knowledge of a trademark examiner, and the trademark office may make mistakes. But that mistakes can be corrected, right? And for instance, the major mechanism to correct the mistakes or errors made by the trademark office, the trademark examiners are the so-called post-granting proceedings, as we explained here. So you successfully registered Chanel for toilet products, but that registration could be invalidated by Chanel trademark owners um, without the time limits. Here as you can see from the slides, the 5 year and time limits is not applicable to bad faith registration of well-known marks. You see, the well-known mark benefits a stronger, much stronger protection than an average or normal trademark that's not that well-known. Basically, that's all the grounds for deny or opposition or invalidation of trademark registration in China. How about the United States? Basically, the grounds for or the grounds on which a mark registration can be denied or invalidated are quite similar from country to country. And here is a brief explanation to those reasons for denying trademark registration in the United States.
Okay, so what are some reasons why the U.S. Patent and Trademark Office might reject a application for protection of a trademark? Well, we talked about in a previous video the requirements that a trademark have certain distinctiveness or secondary meaning, and we gave the scale that it could be fanciful, arbitrary, suggestive, or descriptive, and achieve that distinctiveness or secondary meaning as long as it doesn't reach the point of becoming generic. Okay, but common reasons why the Patent and Trademark Office would reject the application beyond it simply being generic is the mark is too similar to another mark that's already been registered, that somebody else uses a mark so similar to represent their business that granting you rights in that trademark would cause confusion between your mark and that mark that's already registered. So basically someone got there first. Okay, now the mark could have certain prohibited symbols or reserved names or designs by other people. So if you include somebody else's trademark image or design or copyrighted words or something like that within your trademark, then again, that could be infringement on their intellectual property rights, and it could be rejected for that reason. Another reason would be, say the mark merely is descriptive, but you can't demonstrate sufficient secondary use or meaning to say sufficient use to say that it is achieved secondary meaning, that people now equate this description of your product or service that you're trying to trademark as being associated with your trademark. So if it's too descriptive, again, without achieving distinctiveness through secondary meaning, the Trademark Office may reject it. And lastly, if it was protectable at some point in time, but has become so used in a generic sense, such as I'm going to Google this to look up something on the internet. If Google ever allows that word to become used synonymously with look something up to the exclusion of every other term, then it could become generic. Okay, so that would just be an example. Xerox also faced that threat at one point in time because individuals thought Xeroxing was the equivalent of photocopying it. Okay, so in that sense, a word that was once protectable could become generic, and in that sense, if it's generic, again, the Patent and Trademark Office will reject it.
So basically, a mark or a registration to be denied or invalidated or opposed um, in this country it would highly possible that is would also be the case in another jurisdiction. And also the grounds, the reasons for denial, for opposition, for invalidation are quite similar. And those grounds reasons are significantly they explained in the previous session in session 2, and those are all statutory requirements for registration. For instance, distinctiveness, not against the morality, and it's not a generic term,